Welcome to this unidentified channel. Today we are going to go over the last 7 pages of the order that Judge Stephen Boyce signed disqualifying Mark Means as Lori Vallow Daybell's attorney. And we're starting right now. All right, we're going to start in the middle of page 10 where it says analysis. If you haven't read through the first 10 pages, please stop now. Go watch or read through the first 10 pages of this order, and we're going to wrap up the last 7 here. Analysis, here we go. Death is different. See Woodson versus North Carolina, 482 U.S. 280 96 S CT 2978 1976. The duties of the trial court are many, but the overarching duty is clear. Protect all parties' rights to a fair proceeding. Where capital punishment is a legitimate potential, the court's duties to protect a fair and orderly proceeding are unquestionable. The state has raised the issue of a conflict of interest in Mr. Means' ongoing representation of Vallow. The court has not taken these allegations lightly, nor has it been hasty to render a decision about the issue. Instead, conducting hearings and in-camera inquiry and striving in all aspects to render justice and protect the interests of all parties during these proceedings. Further, the case at bar is stayed pursuant to orders previously issued under IC 18-211 and 212 after determination that Vallow is currently not competent to proceed. Procedurally, this case is in its infancy, where Vallow has yet to be arraigned due to the incompetency finding and subsequent stay in the case. However, this case commenced with an indictment issued May the 25th, 2021, and thus the issue of a potential conflict has persisted for several months, notwithstanding the stay of the case. Further, while the case is currently stayed, the court has considered the regularity with which pleadings continue to be filed by the parties, and thus the court determines that the matter is ripe for determination at this time. 1. The court has reason to know that a conflict exists. The state has on several occasions raised the issue of its allegation of a conflict and brought the issue to this court formally through a motion filed July the 27th, 2021. The court held hearings related to the issue and ultimately conducted an in-camera inquiry into what defendant Chad Daybell knew and or understood with respect to the possible conflict of Mr. Means' concurrent representation. Both defendants Daybell and Vallow, through counsel, have acknowledged the issue, which was brought to the forefront of the case when it was determined by the court that an in-camera inquiry was necessary and was conducted. Thus, the court has a well-founded reason to know that there is a concern that a conflict exists. 2. An actual conflict of interest still exists in the case at bar, as found by Magistrate Judge Edens in a related case. This issue has been thoroughly addressed in an earlier case brought against Vallow. This court has also additionally analyzed the issue and reviewed the record in regards to the conflict issue. Taking all of that into account, the court finds that the record demonstrates that Mr. Means, in his capacity as a licensed Idaho attorney, represented Mr. Daybell between April 2020 and June 2020. The record is also clear that Daybell and Vallow are now charged as co-conspirators with multiple felony counts, including charges of first-degree murder, and that Mr. Means is Vallow's current counsel of record. Finally, the indictment issued in cases CR 22-21-1623 and CR 22-21-1624 sets forth alleged overt acts relating to the alleged conspiracy between Daybell and Vallow that occurred on or between October the 26th, 2018 and June 9th, 2020. Which time frame includes the time when Mr. Means represented Daybell. Thus, the court concludes that Mr. Means concurrently represented the co-defendants in those cases within the time frame of the alleged conspiracy. In previously determining that there was an actual conflict of interest on account of Mr. Means' former representation of Chad Daybell, Judge Edens held that given the fact that 1. The defendants had since retained separate counsel, and importantly, 2. that the charges contemplated in that case carried a maximum penalty of 5 years of prison, and thus did not rise to the serious nature where a defendant could not rationally choose concurrent counsel, that the conflict could be waived in that case. The record reflects that Judge Edens questioned conflicting information provided to the court about the date of the waivers and whether they had been properly executed. Judge Edens emphasized that an acceptance of the waivers, even if dubious, was expressly limited to the case before him, and that should a subsequent case or subsequent charges be filed with more severe penalties, the waiver would likely not be honored, and a per se conflict would need to be addressed. Thus, nothing has served to cure the actual conflict which has carried into in the present case, based on Mr. Means' concurrent representation of Daybell and Vallow and the timing of that representation. It is clear that the defendant's previous cases arose from some of the same facts and occurrences that state has alleged to be at the root of the pending murder charges in this case, which indisputably elicits a heightened scrutiny given the potential for the death penalty to be brought herein. Further, the defendants were charged together in a single indictment in their pending cases and are both charged as co-conspirators. 3. Given the maximum possible penalties associated with the charges in the conspiracy case, including the death penalty, the conflict of Mr. Means' former representation of Chad Daybell cannot be waived as it triggers a per se ineffective assistance of counsel concern. The court is aware that both Daybell and Vallow proffered a waiver of their right to conflict-free counsel in case CR 22-20-0838, where Judge Edens found an actual conflict but permitted the waiver. However, the cases now before the court are distinctly different and require a new analysis. Further, even were this court able to determine that a waiver offered here was effective as knowing, intelligent, and voluntary, a defendant's waiver is not dispositive of a conflict inquiry because courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. The court finds an actual conflict. Daybell indicated in the court's in-camera inquiry that he never believed Mr. Means was his attorney. He did, however, acknowledge that he had previously talked to Mr. Means and called Mr. Means when the search warrant was executed on Daybell's property. This occurred prior to the arrest and subsequent charging of Daybell for the murders of Vallow's children and Daybell's first wife. That acknowledged communication between Mr. Means and Daybell, in conjunction with the previously noted representation Mr. Means himself made indicating he represented Daybell, led the court to conclude that Mr. Means did represent Daybell, although the extent of the representation is unclear. Because Daybell and Vallow are named co-conspirators, necessarily they have interests adverse to one another, and each has a right to counsel who is free to zealously advocate for each of them independently, without that ability being hampered by a conflict of interest. The Sixth Amendment guarantees each criminal defendant the right to assistance of counsel unhindered by a conflict of interest. U.S. Const Amend V1 U.S. v. Elliott 463 F 3D 858 9th Cert 2006. Petition for cert filed U.S. October 10, 2006. Given these facts and the charges at hand, the court determines that even if waived by both Daybell and Vallow, the conflict would persist in this case such that Mr. Means' continued representation is untenable. Another consideration weighs into this decision. Capital charges are more than a mere possibility in Vallow's case. As such, Vallow has the right to death penalty qualified counsel if she is represented by a public defender. Mr. Means is not presently certified to represent clients in capital cases. Because death is different, this court must ensure that at every critical stage of her case, she is represented by counsel who is able to zealously and competently advocate on her behalf. If and when Vallow is restored to competency, the court could conduct an inquiry into her interest in waiving qualified counsel. However, until such time, this court's duty to protect her rights remains. The court has determined that the best protection for her exists in the appointment of a death penalty qualified public defender, and on August the 6th, 2021, appointed as co-counsel attorney R. James Archibald. This decision came in part because of the request of Mr. Means, who had been Vallow's privately retained attorney, for a finding of indigency. Further, her commitment to the Department of Health and Welfare carries with it a presumption of indigency that further led the court to determine that it was necessary to issue the order appointing Mr. Archibald on August the 6th, 2021 as co-counsel in this case. Finally, the very actions taken by Mr. Means raise questions about his ability to continue in his representation of Vallow. Concomitant to a conflict analysis is an analysis of whether the decisions of counsel demonstrate their ability to uphold their duties to clients, past and present. Mr. Means has potentially made himself a witness in the case by filing multiple pleadings in the form of declarations containing factual assertions of Mr. Means submitted under penalty of perjury. That unusual manner of practice has further caused the court to be concerned about the effectiveness of Mr. Means' representation of Vallow in the case. Also of concern is a possible intentional or unintentional waiver of Vallow's attorney-client privilege, where Mr. Means has submitted to the record purported facts from statements Vallow made to Mr. Means under the umbrella of the privilege she enjoys while she has been deemed incompetent to proceed. This is precisely the situation that ethics rules caution against, where the rules stress that lawyers should avoid becoming witnesses in their clients' cases. An actual conflict exists in this case due to Mr. Means' former representation of Daybell and the timing of that representation, and Daybell's waiver is insufficient to overcome the risk of harm in allowing Mr. Means to remain counsel to any party connected to this case. Additionally, Mr. Means' practice of submitting declarations under penalty of perjury have called into question his ability to competently and effectively represent Vallow going forward. Despite the pending stay in this case, finally, the court, in balancing the rights of Vallow to counsel of her choice and her present inability to be thoroughly examined to ascertain whether she could knowingly, intelligently, and meaningfully waive her right to conflict-free qualified counsel, given the potential for a penalty of death she faces in the crimes she is charged with, must cautiously act to protect her rights. On balance, because conflict questions should be addressed by trial courts on a case-by-case basis, where the court takes individual situations into consideration to determine whether a defendant's right to counsel is threatened by competing interests. The decision of the court is to remove Mr. Means as counsel to continue the appointment of R. James Archibald as counsel in this case. Conclusion? For the foregoing reasons, the state's motion is granted. Mr. Means is hereby disqualified as of today's date from representing Lori Noreen Vallow Daybell in Fremont County case CR 22-21-1624 and all matters substantially related thereto. It is so ordered. Dated this 28th day of December 2021, and it is signed by Judge Stephen Boyce. We made it through. That's page 16. What is on page 17? It's just the certificate of service, I guess of who it went to. What do you think about Mr. Means being disqualified from Lori Vallow's case? Did you think it was going to happen? Did you know they were looking into all of this stuff? I sure didn't. I am so glad to be through that order and moving on. I may or may not summarize it. I do know it was very long. If you are still here with me through all of that, I give you a big shout out and I appreciate you very much. If you haven't already, let me know where you're watching from and I will see you next time. Should I reread that? Is that a sentence? It's a long sentence. Okay, here we go. I'll read it again. All right, we're gonna start. But the overarching, this is under the umbrella of the sets forth alleged overacts. It's fun to be able to see, yeah, okay. We have a kitty in the house. We have a kitty in the house. Say hi, Miss Kitty. We gotta go, babe. You can't be up here. The court is aware that both Daybell and Vallow proffered, I guess? Proffered. All right, okay, we're just gonna go with it. Here we go. For a finding of indigent, I guess it says concomitant. I don't know if I said that right. All right, well, containing factual asserts submitted to the record purported facts from statements Vallow made to Mr. Means under the umbrella to the record purported facts. All right, so just kidding. All right, take a drink. Bye.